Right, good morning everybody. Welcome to Countryside Rights of Way panel. It's still a fairly sensible temperature outside, but the forecast for the next few days is for it to be very hot, so I'll reiterate the other advice, and please keep cool and keep hydrated. Not dehydrated, keep hydrated. Right, so we'll start today's Countryside Rights of Way panel meeting. Myself and David are here, but we should have some apologies.
Yeah, good morning, Chairman. We've received apologies from Councillor Hudson and Councillor Pritchard.
I've got no declarations of interest. Have you, David? Declarations of interest? No. Okay. We'll move on to item number 3 then, which is the minutes of the 17th of June. I propose that we take these as read. Are you happy with them? Okay. I'll just sign that off. Thank you. And we'll move swiftly on to item number 4, which is the Wildlife and Countryside Act 1981 application for upgrading public footpath 52, Swinnerton, to a public bridal way. And we've got, is it Hannah or David? Hannah, please.
Yes, that's me. Thank you, Chair. Okay, so as stated, this is an application to upgrade public footpath 52 in the parish of Swinnerton to a public bridal way. So the application has both historical and user evidence to support it. So to begin with, if I just go through the user evidence that was submitted with the application. So 5 user evidence forms were submitted from members of the public who have claimed to use the route as a bridal way. So just to outline, for the application to be successful based on user evidence, it will have to be shown that the public have used the alleged route as of right and without interruption for a period of at least 20 years prior to the status of the route being brought into question, or that it can be inferred by the landowner's conduct that they had actually dedicated the route as a public right-of-way and the right-of-way had been accepted by the public. So in terms of the right to use the route being brought into question, there needs to be some evidence that there has been a challenge to using the route. In this case, there doesn't appear to be any specific evidence from members of the public that show that they have been prevented from using the route. So therefore, in this case, the date of the application is taken as the date of challenge. The application was made in July 2000, therefore the relevant 20-year period is from 1980 to 2000. None of the users who submitted evidence have shown that they've used the route for the full relevant 20-year period. 3 of the users' evidence of use does fall within the relevant 20-year period, and when added together does equate to over 20 years of usage of the route, so therefore that could be classed as one user. None of the users have indicated that there has been any challenge to use of the route, although they all do confirm that there are locked gates at either end of the route, but they state that there is an access gap which they indicate is large enough for horses to fit through. This is in contradiction with the evidence submitted on behalf of the landowners, Lord Stafford's estate. They state that the access gap is solely for walkers, in line with the route being classified as a public footpath. They advise that the gates were erected in 1993 specifically to prevent vehicular rights, but also they state that horse riders were informed that the route was not a bridle way. So all the users have confirmed that they have used the route on horseback, which is consistent with the status of the way being claimed. The frequency of use is fairly regular. However, the fact that there is only evidence from 5 members of the public would suggest that the route is not widely used by horse riders, and therefore it could be argued that the level of use would not be sufficient to bring home to a landowner that a right was being asserted over their land. The landowner has argued that the presence of public footpath signs and the removal of public bridleway signs that were incorrectly put up by the local authority shows the intention not to dedicate the route as a bridleway. So overall, there is simply just not enough evidence of use to support the claim that the path is a bridleway, and it does appear signs were in place confirming that the route is only open to walkers. So those are the main points from the user evidence. So if we just have a look at the historical evidence. So when considering the historical evidence, the applicant submitted a number of pieces of different documentary evidence. One of these pieces of evidence was 1910 Finance Act material, which included a map and field book. So the map shows a route, Common Lane, which is the alleged route, and that's still how the alleged route is referred to in modern day. So the map shows Common Lane running along the same line of the alleged route, and it's shown separate from adjacent land holdings. There's nothing from the field book to suggest that any deductions were made for bridleways. The fact that the route is shown separate from the adjacent land might suggest that the route was a public highway. However, alternatively, it could have been shown as excluded as there was no owner and that it was a private right-of-way. So where a route is shown separate from the land, it is likely that its status was higher than a footpath or bridleway. Another point just important to reiterate with this application is that what is not an issue with this report is whether the route is public, as the route is an existing public right-of-way. The issue is the nature of the rights over the route. It could be argued that there is evidence to suggest that the route has rights over it higher than a footpath or bridleway, but there is no real clear evidence from the 1910 Finance Act material to clarify how the route was used and therefore the nature of any rights over the route. A Swinnerton tithe map was also submitted with the claim, which again shows the route is separate from the adjacent land and the route was unnumbered. Again, where a route is shown separate from the land, it is likely to have higher rights over it than a footpath or bridleway, but again, these could either be public or private. The important thing from the Commissioner was the land was untithable and not the status of the way. On the tithe map, the route is coloured orange, which may indicate that the route was public, but again, with no further information, there is nothing to indicate the nature of the rights over the alleged route. A number of maps have been submitted, including OS maps and other old maps. So whilst they show the physical existence of the route, they do not provide any indication as to the nature of any rights over the alleged route. And again, that can be said for the same for the railway deposited plan that was also submitted. So therefore, when all of the evidence is reviewed together, there is nothing conclusive to clarify the nature of any rights over the alleged route or how the route was being used. On initial consultation, Swinnerton Parish Council advised that they would have no objection to the footpath being upgraded to a bridleway. We also received correspondence from North Staffordshire Bridleways Association, who advised that they are of the opinion that when the route was downgraded from a RUP, so from a road used as a public path, during the special review, it should have received higher status than a footpath. The chairman of the association stated that they had ridden the route on a number of occasions over an 8 to 9 year period, and their use of the route had never been challenged. The association supports the application, and it was them who submitted the user evidence forms in support of the claim. As already stated, the landowner, Lord Stafford's estate, is of the view that the route is a public footpath only. On circulation of the report, comments were received at the beginning of this week. The comments that were received were in relation to the special review that was carried out as a result of the Countryside Act 1968, which was undertaken to reclassify RUPs. So, as already alluded to, the route was originally classified as a RUP. Under the special review, the route was reclassified to Public Footpath 52, which is what it is today. Objections were raised at the special review and evidence was submitted that the route was used by motor vehicles. It was, however, concluded by the inspector at that inquiry that although evidence had been provided that there had been usage for over 20 years by cars and motorcycles, on review of historical maps there was no evidence of public vehicular rights, and therefore the claim for byway status had not been satisfied and that the route should be classified as a footpath. At the time of the special review, no claim was made for bridleway status and no mention was made of the route being used specifically as a bridleway. There was a suggestion that the inspector had concluded that rights with mechanically propelled vehicles had been shown to exist over Swinnerton, RUP 52, but on the review of the report, this was found not to be the case. So therefore, its officers' view that public vehicular rights were not determined to exist over the route, and therefore any coexisting bridle rights had not been shown to exist over the route either. Also, following circulation of the report, it did come to light that a response had been received following initial consultation on behalf of the Byways and Bridleways Trust. Unfortunately, this piece of correspondence was not with the file when it came to be reviewed and the report drafted. However, the correspondence has been made available and it was attached at Appendix U for members to view. The writer, on behalf of the Byways and Bridleways Trust, disagreed with the status that was being applied for. They are of the opinion that the route has public vehicular rights over it and should be recorded on the map as an unclassified road or a byway open to all traffic. So when we consider the relevant legal test for this application, the relevant test is section 53 3C2 under the Wildlife and Countryside Act. So that is whether on the balance of probabilities the route should be shown on the map with a different description, so whether the route should be upgraded to bridleway status. So to conclude, it is officers' opinion that the user evidence submitted is not sufficient to meet the statutory test, as there is insufficient evidence to show that the route has been used uninterrupted for 20 years, or that the landowner had dedicated the route for equestrians. It is also considered that the historical evidence is not sufficient to conclude that the route has bridle rights over it, as the documentation does not clarify the nature of any rights over the alleged route. Therefore, it's officers' opinion that the evidence is insufficient to show on a balance of probabilities that the route has bridleway status, and therefore it's officers' opinion the route should remain as a public footpath. So that summarises the application. I'm happy to take any questions. Thank you.
Hannah, thank you very much. A concise and evidence-based report. Thank you very much. David, do you want to make any comments?
I think the report's very comprehensive and very full, and I would like to move the officer's recommendation.
Thank you. Yeah, two pieces of evidence which particularly sort of resonated with me were, first of all, that it's actually been in front of an inspector in 1981, I think it was, who deemed it to be a public footpath. That's got to be fairly telling for us as a semi-legal panel. And the other point for me, and it's something more community-based, is Lord Stafford has actually given permission for a charity ride. Now, if he needs to give permission for a charity ride, it's obviously not a bridleway. So for me, I would agree entirely with what David said and second it, and I think the two of us basically agree with the officer's recommendation. So thank you very much. And we'll move now, please, on to item number 5, which is the Wildlife and Countryside Act 1981, application for a public footpath 15 millage to a public footpath 2 in Lee. Thank you, David. It's page 95.
Thank you, Mr Chairman, members of the panel. And just to confirm that we've received no comments or presentations from the local member. I will move straight to the recommendation, which is that your officers do believe that there is sufficient evidence to show that a public right-of-way does subsist on the balance of probabilities and that it should therefore be added to the definitive map and statement for the Borough of Stafford and with the status of a public footpath. If you turn to the plan at Appendix B, you will see the route clearly marked and running from points A to B. The application was based solely on historical evidence, and it was interesting to note that it highlighted two potential connecting routes in relatively close proximity, and both of these were identified during the application process by the applicant. Either of these would appear to act as a good connecting link to the surrounding highway network, and this of course appears to have been a key reason the application was made. However, as is laid out in the application, there was only sufficient evidence to enable one of these routes to become the subject of the claim. In support of this application, the applicant has submitted several pieces of evidence, the most significant of these being the enclosure ward and plan for Millwich, dated 1787. In addition, the applicant submitted evidence from the 1910 Finance Act, the tithe map, 2 ordnance survey maps, a parish plan and an estate plan. All of this evidence is contained within Appendix C of the report and numbered 1 to 6. Several landowners were identified and landowner response forms were received. All of these are visible at Appendix D to the report and all have been considered very fully by your officers. Mr Wewall did not return a landowner response form at the time of the initial consultation in 2002, although your officers have since discussed the matter in detail with the family representative. This latter evidence can be seen at the addendum to this report and again has been considered very fully by your officers. The application is made under section 53C1 and the legislation accepts that the route may no longer be visible on the ground. This is clearly the case in this application as no physical evidence remains and as the comments from the landowners suggest, the route has never been used in recent times. The alleged route runs between 2 existing public footpaths, being Public Footpath 15, Millwich, and Public Footpath 2, Lee. Of the 6 categories of evidence provided, all rely on historical maps or plans, and your officers consider each of these very fully before arriving at their recommendation. Of all the documents submitted, the Millwich Enclosure Ward of 1787 was perhaps the most significant, and the evidence within it is definitive and clear. Not only does it refer to the alleged route as a public footway, it gives an accurate descriptive of where it was and the line that it took. This is further supported by the accompanying enclosure plan and ratified by the fact that the commissioners who set out the award had the relevant authority to do so. The lattermost point is given in the preamble to the award stating that we, the said commissioners, or any two of us, are authorised and requested to set out, ascertain and appoint public and private roads, highways and footways. It is particularly interesting to note the wording in the preamble in this particular case as it refers to the power of the commissioners to set out both private and public footpaths, and we have an example of each in the body of this report. Enclosure award evidence carries significant legal weight, and in this case the award clearly sets out the route as a public footway. There can be no doubt. Turning to the Finance Act evidence of 1910, it can be seen that the alleged route is marked FP and runs through plot 2423 on the plan, again providing good supporting evidence. That said, there is no reference to it in the associated field book, despite the route continuing through plot 630 where it is recorded under the descriptive restrictions footpath £40, indicating that this section of it at least was a public path. Clearly there is a disparity in the evidence here in that we have the claim route marked on the Finance Act plan as a footpath transversing several plots of land, but only shown in the field book entry to be a public path in certain sections, the claimed one not included. The Finance Act evidence is therefore suggestive of the alleged route being a public path, but not necessarily confirmatory of it. Notwithstanding, when taken together with the more definitive enclosure award, it may be seen as relatively good supporting evidence. The applicant also supplied 2 ordnance survey plans dated 1882 and 1901, which you will see at the Appendix C4 of this report. Although, as the panel will be aware, these are of very limited legal value and merely show the physical existence of the route. As such, all that can really be said of them is that they support the contention that a route of an undefined legal status existed along that particular line. At best, this is limited to tentative supporting evidence. The applicant also submitted a Fradswell estate plan of 1920, a copy of the Millwich tithe plan, also a parish plan dated 1833, although none of these show the route in question. This is not greatly detrimental to the claim, however, as in each of these cases the evidence is not of sufficient probity. The estate plan and parish plan are typically held to be examples of supportive rather than conclusive evidence, while it is probable that a public right-of-way with the status of a footpath may not have been shown on the tithe map, and so nothing turns on these. Although the evidence is somewhat limited, the probity of the enclosure award is good, and the courts have ruled that these can be taken as conclusive evidence in the absence of any later legal events. There is enough, therefore, for your officers to posit that the route subsists on the balance of probability. Had the enclosure award not been clear, or the plan had been missing, or any combination of these events, then it would not have been possible to satisfy the higher test. However, in this case, each is clear and each supports the other. The applicant presented additional evidence within the same application for an alternative route that runs to the north of the route in question. He stated that this would be an equally acceptable route as it also links to the surrounding footpath network and is a clearly defined track currently used as a private access lane. However, there is no evidence that this alternative route had ever been public. Indeed, the same enclosure award that supports the public nature of the claim route clearly shows the private nature of the alternative route. As such, a case cannot be made out for it, and so the subject of the claim remains as stated. The applicant did suggest a possible future diversion of the claim route onto this alternative route should the application be successful, although that, of course, is not a matter for this tribunal of fact. Indeed, we only mention it at all as it was part of the applicant's original submission, and it also provides a very good example of the probity of enclosure awards, which can, in the absence of other evidence, be conclusive of both public or private rights. For the interest of the panel, the details relating to this are given at Appendix F to this report. Turning to the comments received following the circulation of the report, your officers can confirm that nothing was received that was material to the claim. A representative of the Wewall family, one of the landowners concerned, met with your officers and discussed the application in some depth. It was suggested to officers that the route was inaccessible and that it was not visible on the ground and that no one had known anyone to use it in recent times. All of these points were and are respectfully acknowledged by your officers, although, as the panel will be aware, they have no legal bearing on the claim. There was also the suggestion from the Wewall family that there had been a diversion of a footpath in the vicinity of the claim route some years ago, although as the alleged route is not on the definitive map at present, it is likely that this referred to another pre-existing footpath that already had its legal status. A colour aerial photograph was also supplied by the same family, and again this can be seen in the addendum. Although of limited legal value, it does illustrate the position on the ground, although again is not material to the claim. Notwithstanding, your officers are much obliged to the landowners for taking the time to discuss the matter with us, and sincere thanks is accorded in this respect. As the panel will be aware, the application only seeks to determine whether or not the alleged route subsists in law, and all other concerns, such as the points previously raised, have to be discounted. Moving to point 55 of the report, the panel will see that there is no evidence to support any higher rights than those applied for, and as such the claim is limited to the status of a public footpath. In summation, this has proven to be a straightforward case that rests almost entirely on the probity of the enclosure award and plan. Each are clear and each supports the other. The officers can only reiterate that good enclosure evidence is almost akin to a legal order, and when of this quality and clarity, it is practically conclusive. In addition, it was further supported, in part at least, by the Finance Act evidence, somewhat disparate as it is, and backed up tentatively by the Ordnance Survey plans. As your officers will contend, after taking everything into consideration, it is apparent from all the evidence available to them that a right-of-way with the status of a public footpath does subsist on the balance of probabilities, and recommend, therefore, that it should be added to the definitive map and statement of the public rights-of-way for the Borough of Stafford. Your officers further recommend that the route should be made out to the standard minimum width of 1.5 metres throughout its length. Thank you, Mr. Chairman, and I'm happy to take any questions.
Thank you. Again, an informative report. David?
I suppose one starts to get caught up in the addendum to the application. Am I correct in the line of a footpath is the line of the footpath? If it's not passable because someone has chosen to divert it, unofficially divert it, and run parallel to it or whatever, that doesn't affect the status of the footpath, and they would then, I think, as you said, have to apply for a diversion order. So we are approving, at least I assume we're approving, because I'm happy to propose it. We're approving effectively an impassable footpath because there's another one in use. So someone's got to pick up the cudgels and bring it back to us with a diversion.
Again, thank you, Mr. Chairman. I mean, that would not be a matter for this tribunal, in fact. If a diversion was sort of considered in the future, it would be between the landowner and any other party.
Thank you. Just from my point of view, the evidence is there. It's solid evidence. It's historical evidence, and I don't think if we were minded to disagree with this, we couldn't. So I'm more than happy to carry on with the approval. Just quickly, I thought in my head, and that's a strange place to be, that it was a metre for a public footpath. It's standards of 1.5 metre.
Yes, Mr. Chairman, it's a metre for a cross-field path, 1.5 metres for a headland path or a field edge path. The nature of this route through Myatt's Wood would have had more the character of a sort of a headland path. There would have been growth, and there's a deal of contention and conjecture in this, but on balance, it's more likely that this would have been the character of a headland path rather than a cross-field path.
Bearing in mind that it is the historical path, and I agree on that one, but it's also running across fields now. Could I suggest that we actually make it a metre rather than 1.5 metres? I don't know what David thinks.
Chairman, if that's your suggestion, I'll go along with it.
So I would like it to be a metre width rather than 1.5, bearing in mind that it's now, as David said, we're imposing this on someone who's got fields there, so I think it's more reasonable. So thank you. We're happy with that?
Yes, thank you, Mr. Chairman. Yeah.
Thank you very much. Okay, we'll move on now to item number 6, which is Wildlife and Countryside Act 1981. And this is an application for the addition of 3 alleged footpaths at Hickson Airfield, Stafford. And again, David, thank you.
Thank you, Mr. Chairman, members of the panel. And I should just reiterate that we have received no comments or representations from the local member. Okay, this was an unusual, if not unique, application concerning 3 alleged routes running along disused, and we stress disused, Mr. Chairman, airfield runways. The application was for 3 routes, all within the status of public footpaths, 2 of which followed the course of former runways, and the 3rd which bisected both of these runways at Hickson Airfield. I'll move straight to the recommendation, which is that the evidence is sufficient to show that the 3 alleged routes can be reasonably alleged to subsist as shown on the plan attached to Appendix B. And if you turn to that plan, you will see Route 1, Route 2 and Route 3 clearly marked. This was a joint application by Stow-by-Chartley Parish Council and Hickson Parish Council, and you will see a detailed description for each of the application routes at paragraphs 2A, 2B and 2C of the report. To summarise this somewhat, the first alleged route runs from the southernmost end of public footpath 34 Stow-by-Chartley to a southern point of public footpath 32A Stow-by-Chartley. The second alleged route runs from the southwesterly point of public footpath 23 Hickson to public footpath 32A Stow-by-Chartley. The third alleged route bisects the first 2 alleged routes and runs from public footpath 37 Stow-by-Chartley to the northern point of public footpath 23 Hickson. The joint applicant submitted 32 user evidence forms in support of the application from members of the public who claimed to have used the alleged routes for varying periods of time, and these can be seen in Appendix C to the report. In addition, the applicant submitted further details including a problem area map illustrating obstructions across alleged routes 1 and 2 which were present at the time of the application. Although based mainly on user evidence, the applicants also submitted some historical documentation which was also considered by your officers. However, the probity of this was not sufficient to say that it constituted a mixed application. Your officers also received a landowner response form from one of the landowners identified in the report, and this can be found in Appendix D. It was interesting to note that all 3 of the alleged routes crossed the parish boundaries of both Hickson and Stow-by-Chartley, and all were linked to existing rights of way. For the application to be successful, it will be necessary to show that the public have used the said routes as of right and without interruption for a period of at least 20 years, or that by the landowner's conduct he had so dedicated it to the public and public use, and this use had been accepted by them. Turning to the critical date of challenge in this application, your officers note that there appear to have been many ongoing challenges to the claim route, and various obstructions have been made along 2 of the routes at varying times, some of which have later been removed. Notwithstanding, the relevant 20-year period for this application varies somewhat between the routes, and each case will be taken separately. As such, for Route 1, the challenge came in the form of a coffee mountain in January 2007, and therefore the relevant period runs from 1986 to 2006. For Route 2, the date of challenge was in 2010, when aircraft and parts of aircraft blocked the alleged route. As such, the relevant 20-year period was calculated to be from 1989 to 2009. For Route 3, the date of challenge appears to have come in 2011, when a gate was placed at the southernmost end of the said route, and as such, the relevant 20-year period was deemed to run from 1990 to 2010. Turning to the user evidence itself, your officers found that of the 32 users who submitted forms, 17 testified to using all 3 routes for a full 20-year period prior to the use of any of them being brought into question. This is just over half, and therefore constitutes a significant number of users with relevant evidential value. There are further 7 users who testified to using parts of the alleged route prior to the date of challenge, and a full breakdown of this and other part usage is given in the report from points 19 to 25. For ease and clarity, however, it is the 17 users who used all 3 routes throughout the relevant 20-year period that is most significant to the claim. Of these 17 users, a total of 15 claimed to have used the routes on at least a weekly basis, and only one of these claimed to have used them seasonally, the lowest frequency encountered. Significantly, all of these relevant users stated that they had used the route on foot, although incidental reference was also made to bicycle use. Nothing turns on this, however, as the predilection throughout the evidence is that the routes were used on foot. The same witnesses did report seeing several different types of vehicle throughout the relevant period, although these references are merely anecdotal and no case has been made out for hire rights. You can see these references at points 28 of the report to 29. As stated earlier, a number of different obstructions were placed on 2 of the routes and at different times. These range from coffee mounds or mountains, tip rubbish, pig pens and fences on Route 1, and the reference to them are repeated consistently in the evidence. A more precise outline of them can be seen between points 30 and 33 of the report. The situation on Route 2 was no less severe, with obstructions including fencing, barriers, hindrances, rubbish, aircraft enclosures, disused aircraft parts, scrap vehicles and planes, while Route 3 eventually had a lock gate positioned at one end. However, the critical point is that the routes were only obstructed at the date of challenge, and anything prior to this was incidental and did not block the route. Again, many of the users did testify to seeing signage along the route, although few, if any, details or even a location was given in most cases. Where further details were provided, they seemed to confirm that this signage, whatever it was, fell outside of the relevant 20-year period, with 2011 being cited as the commonly agreed date. The historical documentation submitted with the application includes notes relating to restrictions on access, highlighted at point 44 of the report, and affecting the land from 2007 to 2011. These restrictions merely refer to the debris that started to appear on the routes during that period, and although inconvenient, did not fully obstruct them until the respective dates of challenge. The map dating from the 1830s lends no evidential value to the claim, as it does not appear to correspond to any of the alleged routes. Similarly, the 1972-82 map relates to alterations to public footpaths in the vicinity of Hickson Airfield and was produced by Staffordshire County Council, although as the alleged routes were never actually added to the definitive map and statement, it does not add any great value to the claim. This is an application that will succeed or fail on the strength of its user evidence alone. Notwithstanding, additional details were received. A letter from Mr. R. Tong, dated 2012, stated that he had jointly owned and then occupied the land for over 40 years. More significantly, he stated that neither he nor his business partner had objected to local people using the routes for general exercise purposes for themselves, their dogs or horses. That said, the letter is not clear as to whether he owned the land immediately adjoining the estate or the land in question, although references to him in the user evidence forms do suggest that it covered the area of the alleged routes. This would also support the contention by Mr. Greaves, who returned a landowner response form, that he was a joint owner rather than the sole owner of the said land. The landowner response form of Mr. Greaves stated that he did not consider the route to be public. He revealed the land was commandeered by the government in the 1940s due to the Second World War, which most probably set the scene for its later use. Mr. Greaves testified to seeing people both on horseback and on foot using the route, and that he told those on horseback not to use it. He also stated that it had been difficult to monitor the amount of illegal usage of the route. Unfortunately, the landowner response form is somewhat generic and appears to apply blanket fashion to all three of the alleged routes. That said, it is also important to note that only users on horseback were ever challenged. The completed form is visible at Appendix E to this report. Turning to the totality of the evidence, your officers find that all three routes connect to the surrounding highway network. All three appear to have been used unchallenged and on foot throughout the relevant 20-year period, and this appears to have been as of right. There appears to have been no prohibitive signage erected on the route during the relevant period, and the frequency of use seems to have been sufficient to bring it to the attention of the landowner. Over half of all users who supplied user evidence forms were found to have used all three routes for the relevant 20-year period. The only potential detractor from the evidence is a permission referred to by three of the users, and although a permission can indeed be fatal to a claim, in this case it is mitigated by the fact that it was not referred to by any of the other 29 users. Indeed, they testified that no permissions had ever been given. It is also unclear as to which routes exactly were covered by the said permission. They are not specified, introducing an element of doubt as to whether it merely referred to the land as a whole rather than to specific routes. It is very difficult to ascribe any degree of probity to blanket statements where a specific route is not referred to, and so we are left with the possibility that Mr. Tong's non-objection to use, as expressively stated in his letter, was interpreted by the three users as a permission to use. Certainly, Mr. Tong himself did not attest to having granted any kind of permission to any party. He simply did not object to anybody using it. This also has to be taken together with the additional evidence supplied by the applicant, which highlights the fact that since 1962, when the airfield ceased operation, the public were accessing the routes without question or challenge, and that this position had existed long before the airfield came into being, when the land was used for purely agricultural purposes. Reference is made to walkers using the routes on an individually regular basis, and that the network of the three routes should be considered as a whole. There is a contention that the routes be considered that along the runway should replace earlier rural paths, and although this cannot be considered in this tribunal of fact, as it falls outside of the relevant 20-year period, it is duly noted. Again, it is reiterated that Mr. Tong was indeed the owner for over 40 years, and that he never objected to its use. The statement does not refer to any express permissions being granted by him or anyone else. Following the circulation of the draft report, the current landowner of the alleged routes responded through Knight Solicitors and consultant Mike Taylor of Access Countryside Consultancy Limited. The statement submitted by them is given in full in the addendum, and as is your officer's response. There are two key points here. The first being that the officers did ultimately agree that the routes should be made to the standard minimum width of 1 metre and not 1.5 metres as had previously been posited. And secondly, that the inference of obstructions on the route is accurate, and that it was not fatal to the claim because they occurred at different times on each route, and each route had a different 20-year period that preceded it. In each case, therefore, the 20-year relevant period was free from obstruction and so cannot defeat the claim. Other responses to the draft report can be found in the addendum, including communication between your officers and landowner, Mr. Greaves. Each point has been addressed very fully by your officers, and there is nothing of material value with any of these comments to defeat the claim. Your officers recommend that the totality of the evidence be considered, and although the minor reference to permissions is noted, it is not fatal to the claim. Your officers conclude that there is sufficient probity for a reasonable person to reasonably allege that the routes subsist, and as such your officers can do no more than to recommend that an order should be made to add them to the definitive map and statement of public rights of way for the Borough of Stafford. Your officers further recommend this should be to the standard minimum width of 1 metre throughout. Thank you, Mr. Chairman. I'm happy to take any questions.
Thank you very much. David?
Can you give me any background on the airport? I'm assuming that during wartime, the whole of the airfield was completely secure with barbed wire and goodness knows what. So I doubt they ever came to this committee at wartime to ask for the cessation of the footpaths for the period of the war. The only time I've been on there was to visit a company that was using it as a business park, and so I think a significant number of buildings there are used for the business park. So I wonder what the current security is on that park. One imagines that if you've moved on to something which was an ex-military base, that your business park would have security. It doesn't seem to in the case we're looking at. I was interested to know when it was last used for aircraft, because having 3 crossings of the main runway might be quite interesting. I would say it crosses the main runway in 3 points, which unless there had been a cessation of use by aircraft, that would have been extremely interesting. Thank you.
Yes, thank you, Mr. Chairman. We understand the airfield was decommissioned in 1962. Prior to that, we don't have any evidence available to us that the site was secure. So, without that evidence, we can't really say whether it was secured or not secured, accessible or not. We can only go on what the evidence, how it's provided to us on those forms. But certainly in 1962, it ceased to be an airfield from the evidence.
I find this quite interesting. Just going quickly delving back into history, Hickson Airfield was the main airfield in the area, and next to me, Stafford Airfield, which is another. Yeah, Stafford is now an industrial estate, and that was a satellite airfield, and my father quite often sort of recounts stories of Wellington bombers and Lancasters going from the airfield over the fields and crashing occasionally into them years ago. And then you get onto the later history and George Greaves and Rolly Tong and the industrial estate, and it is very interesting. But getting back to the report, it is the sort of thing that this panel, if it's still in place in 20 or 30 years' time, will be doing with HS2, because obviously, as David quite rightly said, when they wanted an airfield, they just moved in and put an airfield, and there wasn't a lot of disputing about rights of way, and if you got run over by a plane, it was your own fault. But in terms of the post-62 evidence, about people walking it and not being stopped walking it, and officers' evidence, I would suggest that we agree with the officers and make a recommendation on this. Are you okay with it, David? Do you want to just use the microphone?
I'm happy to propose, Chairman.
So I agree, and we'll take that forward. Thank you very much for an interesting report. We now move on, please, to item number 7, which is exclusion of the public. And I have words to read out. That the public be excluded from the meeting for the following items of business which involve the likely disclosure of exempt information as defined in the paragraph of Part 1 of Schedule 12A as amended of the Local Government Act 1972 indicated below. Thank you. And can I thank officers for the meeting and the public part of the meeting, and obviously you're still here for the exempt.